Thank you. You may be seated. Good morning and welcome to the First District Court of Appeal. We have two cases on our OA docket this morning. We'll take them in the order in which they were noticed. The first case is case number 25-79, Estes versus Palm Beach County School District et al. Mr. Porcher.
I'd like to reserve 7 minutes for rebuttal.
Thank you.
May it please the court, Randall Porcher on behalf of the appellant, Miss Nancy Estes. In the end, this case turns on the meaning of the word toll. There is no other issue. Now, admittedly, my brief went into grammar and did a deep dive, and I'm going to try to stay away from that today, because if toll is given the proper meaning, everything else falls into place. So the meaning of the word toll here pertains to its operation on a statutory limitation. Its ordinary, expected, and in fact, its dictionary meaning is to suspend or pause. It both describes the verb and it describes its mechanics. No other word will do such a thing, and we have developed a word for that because when we say toll in legal parlance in a statute, absent some exceptional definition, that is precisely what it means. So there's 4 reasons why it should be interpreted that way, and we start off with that is.
So, Mr. Porcher, do we have a problem here with going with a textual approach, because this court has said this court in the past has used a more purposivist and discerned the intent of the legislature and went in another direction, and so toll doesn't mean pause or abate like it would in Black's Law Dictionary, but it means extend in some fashion.
Well, we'll get to that. So do you have a problem? I would think not, mostly because Phillips did not give a definition of the word toll.
But I mean, isn't Phillips what we have here, though? I mean, you've got exactly the same factual situation, it seems, where either the subsequent provision of services applied the 1 year, or it didn't, right? I mean, why
Oh,
isn't
no,
Phillips directly on
I
point?
have to concede that if Phillips is looked at from 30,000 feet and you say, what is the result of Phillips? I still question the result, because the result is, what does toll mean? And so if Phillips gives you the outcome and the input, I lose all day long. But Phillips also stands for something that this court should reconsider. The court said the word toll does not have a definition in the workers' compensation statute. That should be a signal that it doesn't have a special definition. But instead of saying, oh, it doesn't have a special definition, let us turn to a dictionary, they said, so there is this interpretation, but we don't feel, or we do not believe that that's what the legislature intended. Not focusing on the word, in fact, they elided that. Yes.
You're focusing on the word toll in 449.19, but don't we need to read the whole sentence both there and then Judge Tannenbaum in his Ortiz concurrence, equates it to 95.091, the tolling of civil statutes, but the two sentences as a whole are different. 440.19.2 shall toll the limitations period set forth above for 1 year from the date of such payment, where 95.051.1, the running is tolled. So, I mean, pretty clearly 95.051 tolled there means paused, but could not tolled in 440.19 mean extended, since we have a year period there.
And I will get there, but extending is a categorical expression. If you look at the result, I once had 6, I now have 36. Or so I extended my takings or whatever. But it doesn't explain the mechanics by which that was done. I could have added 30, I could have multiplied by 6, I could have added 2 multiplied by, there's a million ways to get there. And we're talking about the statutory assertion of time. So time has its own language, and extend is the vaguest term that you would use. And there is a way to show could we extend time by pausing the time in motion? How could we extend to the observers outside? How could we extend it by pausing the running of the time? And we have a word for that, and it's toll. So extend doesn't answer the question, and in fact begs the question. Now, I have to admit, the Phillips court said what they said, but fortunately they showed their work as well. So it stands for a non-definition of toll. You can't get there. And I'd struggled. I mean, I
And did the Supreme Court, the year after, you cited the Henke case, Florida Supreme Court case in your papers, a year after Phillip, they addressed the definition of toll in a statute of limitations context, and it said it means abate. Does that change our calculus in evaluating Phillip?
I think it certainly could. And, you know, if the purpose of textualism is to bring adherence and integrity and fidelity to the law, I think Philip stands out there as there's no statutory definition of toll, which should send off alarms, which is, okay, so it's the ordinary and reasonable reading, because statutory definitions are only for specialized or modified. And they relied on Best, which cited Black's Legal Dictionary, the definition of toll, and they said, we just don't believe that's what the legislature meant. So if someone tried to use Phillips today to say, this is how we ought to arrive at the meaning of a statute, what do you believe? I think
Phillip
you'd say
has only been cited once, right? As I looked at Westlaw, Phillip's been cited once in 30 years. And so it seems like there's not much that's written on Phillip.
I don't think there is a lot dressing.
Well, and also in Phillip, can you tell me what how much time passed between the accident and the initial provision of benefits?
That I cannot. On rebuttal, I can.
Yeah, you
perhaps
probably
do that.
can't, because I'm not sure they mention it. And my point in that is, despite everything that Philip said, it still was addressing a different issue, I think, than it is like Best. I mean, Best was addressing a different issue than we have here. And so even though Philip goes off and, relies on Best and then, does what they did, and to what extent would a decision like that count as a holding in a case like this, when they don't even address how the tolling actually would work? They just kind of guessed at it or passed by it, and it didn't really show their work. I disagree with you on that. I mean, they just cite Best and just say, yeah, this is how we think it should work.
They inverted the holding him. Yeah. So stare decisis, I mean, it's Latin for we allowed the thing that has been decided to stand, but the question is what has been decided. And really what they decide there is what the judge there, they weren't going to use a dictionary because there wasn't a definition, and there are two interpretations, and we're going to go on our judicial belief. But the problem is it leaves toll as a verb without meaning. And I agree, Judge Bilbrey, I agree that you don't look at one word and fly spec it, but it is the predicate of the sentence on a statutory provision that accounts for the time in the running and a time limitation. So I don't think it's fly specking to say that toll should get its ordinary and reasonable reading in that context, where it is the centerpiece of the statute and everything else falls into place once you get toll right. And that's why I said it turns on toll. I did the grammatic takedown, and I apologize to anyone who had to read it, but I was really trying to find any other verb that would fit. And, quite simply, extend does not do it. It doesn't tell of the mechanics. Extends comes from, it's figurative speech, because it usually talks about a physical item. We extend something, we stretch it. So we don't extend time. Now to the observer.
But the Supreme Court has actually been more specific on that and made the distinction between toll and extend, hasn't it? I mean, extend is a different concept, as is revive. And wasn't that the state of the law before 1994?
Yes, and I haven't gotten to my 4 reasons. Now, told in 440.19 sub 2 is not an isolation or a one-off. In fact, it was created over 440.19 sub 5, which has been in the statute since any of us were born. And it says the statute of limitations is told during the minor or incompetency of a person, is told. Use the word extend if you must, but then the question then becomes, how are you extending it? Oh, by pausing it during that period. And then 440.192 uses the word toll. So the fixed meaning canon would say, well, when they put the word toll in there into a 6 subsection statute that is not indented, it's integrated, it's a fixed meaning, it's consistent meaning, and it should be read harmoniously. So I recognize that Phillips says what it says, and I hope I did a respectful job with that in my brief. But the question is, it's not a substantive right. The best day for Miss Estes is she gets to have the merits of her case heard. Now, that's a good thing, and it's a wonderful, but she doesn't get any extra money. She doesn't get any extra rights, and it is a procedure. And so nobody has a vested right in a procedure. The case is decided on its merits. And,
I'm sorry, but you're running into your rebuttal.
Oh.
I don't want to take up too much, but have you found another instance in all the decisions of the Florida courts where toll has been read to mean extend?
So I think it has been used as a synonymously where categorically.
But I mean, functionally.
No, functionally, it can't.
I mean, people
cannot.
call it, sometimes erroneously refer to it as extend, but functionally.
No, and
as a
mechanically.
tacking on of a period of time to the end of the statute.
Mechanically,
as opposed to stopping
the
it.
word extend means nothing. You can extend by adding, you can extend by multiplying, you can extend by looping, you can extend by reviving, you can extend by pausing the time that's running. And we have a word for that, which is toll. So extend really is a broader category. And so Judge Tannenbaum, I don't know if there's such a use, but if there is such a use, I would challenge them to show me the mechanics, because it can't be done. I mean, that's the good thing about math, is there's only so much that can be done, then you have to prove it. So I thank you. I've run into my rebuttal time.
Thank you.
Thank you.
Mr. Wagner?
May it please the court. My name is Bill Rogner. I represent the Palm Beach County School District. Phillip was my case. That case was handled by my firm, and the facts were identical, and it says so in the body of the opinion. It says that the petition was filed more than 2 years after the date of the accident and more than 1 year after the last provision of benefits.
But does it say when the initial provision of benefits was done?
It doesn't say it.
So then we don't know. It's not the same issue, then, is it?
Well, I do. I know it was the same issue. It was a compensable
Well, but we
claim.
don't. Reading
I
the
understand.
case, no one knows that.
I understand. Let me give you the big picture here. So I was doing this full-time work in 1994. This is all I've ever done in my life, right? And I was doing this full-time. And the prior version of the statute did not have the word toll in it. What it said was you get 2 years, but it can be extended. It didn't say extend, but it said may be filed within 2 years after the last payment of compensation or the last provision of remedial care. We called that provision of benefits a tolling event. That's what we called it.
Who's we?
It was the
The
practice,
industry?
the JCCs, and you. I looked up last night. I found 11 cases between 82 and 92, just the dates I looked, where the court referred to the payment of benefits as a tolling event. That's what tolled the statute. And so what would a reasonable reader have believed tolling meant when that word was put in Chapter 440 in 1993, effective in 1994? And I assert that a reasonable reader would have believed that it was an extension. And we made that exact argument when we brought the Phillip appeal. And here's the key to the case for me. is the court, sometimes I get pushback, they'll say, well, that's just dicta. That's just dicta. That's not central to the ruling of the case. And the court said, and it's exactly the way it's worked, it's been settled for 25 years, it said, we thus hold, a claimant is barred from filing a PFB unless the claim is filed during the longer of the two periods of time. 1, within 2 years from the date of the injury, or 2, within 1 year from the payment of indemnity or the furnishing of treatment. We hold, and that's how multiple generations now of lawyers and claims adjusters and everybody else has interpreted the statute of limitations. And my problem...
Why did the Florida Supreme Court the very next year say that tolling in the context of statute of limitations means a pause?
Okay, well, now I go back to calling
that seems like they are doing, in fact, the heading is plain meaning. I mean, they are doing plain meaning statutory interpretation work.
I absolutely understand that, Judge. I understand that. And I looked at the cases, Judge Tannenbaum, you've written a lot about this. And I looked at the cases that you've cited. And, you know, the Hankey case is a Med-Mal case. The Herndon case is a Chapter 95 case. The McBride is a comp case, but addressing a completely separate issue involving the dismissal and whether dismissals of PFBs told the statute. And so I don't think any of those are anything more than dicta.
Did the Supreme Court talk about the word toll in those cases?
Sure, they did.
Yeah.
And
didn't the Supreme Court say that wherever, or I'm roughly paraphrasing, but where it appears in a statute of limitations context, this is what it means?
Your Honor,
that's how they got
language
from
that's
Chapter
found.
95 to Chapter 766.
I understand. I
Right.
understand. And I guess.
And didn't the Supreme Court also lay out in detail I didn't mention the clock first. The Supreme Court mentioned the clock first, which you've taken issue with repeatedly. So the Supreme Court has explained exactly how that word typically is used, has historically been used and understood. And you're arguing that that's wrong, that the word, if we go back before Phillip and Best, and just go back and you're looking at the word off the bat, we're trying to find the original meaning of that word.
Right.
Are you asserting that the word toll means something other than suspend?
I am not. And if we were sitting here in 1999 arguing this case, if you had been sitting there instead of the 3 other judges that were sitting there at the oral argument held on the Phillip case, and we were considering this as a matter of first impression, I understand the legitimacy of the point of view of my opponent. My question, or my point, though, Judge, in response, is it's a matter of procedural. It's a procedural issue for me. And the reason is, this is not a vague statement about how this statute applies. And I would point out, since 1999, when Phillip came out, the legislature has amended Chapter 440 almost every single year. Almost every single year. And they've never touched 440.19. And this court wrote, with Judge Tannenbaum in dissent, in the Guglielmo case, this year, the legislature is presumed to know the judicial construction of existing law when it amends a statute and to have adopted the prior judicial construction unless a contrary intention is expressed. If the legislature thought you had whiffed in 1999 when you ruled exactly how our statute of limitations applies, they could have corrected it. So they have tacitly
But doesn't that principle apply to the actual provision that the legislature is amending? Because that concept doesn't work, generally speaking, because every legislature is different. There are a variety of political reasons why a legislature doesn't enact a correction, and it otherwise is subverting the Constitution to argue, well, the legislature accepted by not acting, so that's approval of what we've said. That it doesn't work constitutionally, does it?
Your Honor, the other thing that I would point out, and it's really a really important thing to us right now, and we're debating this, is my position is, and Judge Bilber, you wrote about this in the Awolowo case in 2024 in dissent. You were in dissent, but you wrote about this. I have believed forever, and I've been told by judges in this court when I'm up here making an argument, they'll look at me and they'll say, Mr. Rogner, are we not bound by this panel decision unless and until we go in bonk and recede from it? At which point I usually pivot to trying to distinguish my case or argue that it's only dicta. And it is my belief that this is an absolutely clear holding, and it's important because the entire industry has functioned under this definition, or this holding that you gave us in 1999. And if the court is going to change it, should it not go en banc to change it? And the reason I say that is I submit that what we're being potentially encouraged to do is to bring arguments and issues to you again and again, hoping that I get a different panel. Because if you're not bound, if this panel is not bound by another panel, then where is the finality? So what I do mostly in my job is I answer questions for clients. Bill, I've got this fact pattern, what's the answer? And I get the answer not just from the Constitution and not just from the plain words of the statute. If the only thing that mattered were the dictionary definitions of the words in Chapter 440, we can be replaced by chatbots. The law is something more than just the words. And if I can't confidently answer my clients...
So the law also includes what judges say it is, even if it means amending the statute that has been enacted by the elected representatives?
That's a loaded question, the way you phrased it, Judge.
Well, but that's what if we're going to talk about, if our job primarily is to find what the law is and be accurate about it and apply the policy that the legislators have enacted through the process set out in Article 3 of the Florida Constitution, then isn't the first question always, well, what is the actual law? And is it wrong? Is what a court has said about it since then wrong? And then we can get into a policy discussion whether there's good enough reason to reverse or not reverse or overrule that. But the first question, shouldn't it be, what is the law? And what is the law? What does toll mean here? What was the policy enacted in 1994 by the legislature?
That's why I'll get back to my procedural idea, Judge. I'm not suggesting that you can never second guess or revisit a decision that this court makes. In fact, I think you're obligated to reconsider and determine whether a prior panel's decision was incorrect.
The U.S. Supreme Court's done it 230 times or something.
Right.
Right, it happens all the time.
Totally agree, but the Supreme Court doesn't have to go en banc. The Supreme Court's en banc all the time.
Yeah.
And so, and Judge, I know you have written that this requirement that the court go en banc comes from, as you described, absolutely nothing. But
Some of us disagree with that, Mr. Rock.
And Judge, I was pleased to see that you did disagree with that in that Awolowo case that I mentioned earlier.
I think I said that about the prior panel precedent rule.
Well, if I got it wrong, Judge, I apologize. But
Same idea, though.
it's the same idea, and I use the phrase, judicial restraint. Choosing to go en banc to make a decision is an exercise of judicial restraint to make sure, and the rule says, and I know the rule says, the en banc rule says may, absolutely says may. You don't have to go en banc. But why would you go en banc? And there's two reasons. And one of them is to maintain uniformity of the court's decisions. And I suggest that while it's not constitutionally required, it is certainly appropriate. So
you'd be okay if we went en banc and changed it?
I would be disappointed because regardless of the validity of your construction in Ortiz about how tolling works.
It wasn't mine, it was the Supreme Court's description.
Understood. My mistake. It is an almost impossible task, not impossible, a very, very difficult task to calculate because of the nature of our cases, the statute of limitations. This is not in the record, but I recently did a seminar for 14 claims adjusters. I spent an hour explaining the Ortiz two-timer tolling. I gave them a simple example, asked for, tell me when the statute ran. All 14 got it wrong.
Well, but now you're hitting on, I think the real issue here is, so your position is well, the way that Philip came out, it makes it easy for your adjusters to enforce the statute of limitations. And what I'm failing to understand is, why is it an adjuster's job to do any of that? Shouldn't they just be adjusting the claims, paying the claims? And a statute of limitations is a defense if someone files a PFB. Where you have it now is that the adjusters are doing it themselves. And was that what the legislature intended when they amended the statute and made it and added tolling? If they added the word toll, and toll has a specific meaning, it means suspension, and the Supreme Court has described how this works. That it is actually the stopping and starting of a clock, and then you add it up. And then there's extensions, which is different, and you can do both in the same case. That's for a court or a JCC to do after the fact in an affirmative defense, not for an adjuster necessarily to do.
Well, except the adjuster waives the defense by not raising it in her first response. So the adjuster has to understand the statute of limitations, and they don't have lawyers most of the time when these petitions get filed. And they have to understand it because the statute says they waive it if they don't raise it. Now, in my 2 minutes...
But they also have the claims run. So they know when the accident happened. They know when the first benefit was provided. They can...
But then they have to use the countdown timer, and then they have to toll it. It's a very, very complicated. Can I make one more point in my remaining 2 minutes?
You may.
Tolling does not apply in this case at all.
Well, you mentioned that, and that would make it easy on us,
Yes, it would.
an easy out, but you're arguing there that compensability and MCC are the same thing.
I am not.
But they're not. I mean, you would agree that MCC and compensability are different things, right?
Well, here's what I'm going to rely on, the plain language of the statute, because compensable is defined in the statute. It means a determination by a carrier or a JCC that a condition suffered by an employee results from an injury arising out of the employment. That's the statutory definition. What happened here? Well, in February 2023, my client denied the case in its entirety, asserting that the condition from which the claimant now suffers, arthritis, did not result from an injury arising from the employment. What does their petition seek? What does their petition seek? Plain language of the petition for benefits says, details. Claimant seeks compensability of claimant's injuries. So I assert, and the judge made this finding in his motion, in his order on the motion for rehearing, that this is a compensability dispute. It involves whether or not this lady's underlying arthritis is covered by this claim.
Well, and again, that would be an easy out for us, but the notice of denial, the work-related injury is no longer the major contributing cause for ongoing treatment of her right knee. Incident which occurred at work, paragraph 2, is no longer the major contributing cause, meaning at one time it was, and the accident was compensable.
Okay, well, but the accident is not a compensable thing. The injury is what's compensable. That's what's compensable, an injury. And here's what this, again, I'll go back to the definition, Judge Bilbrey. It says that a condition results from an injury arising out of. Results from, that's caused by. So it incorporates a causation standard in the definition, the statutory definition of compensable. It's right there. And so this wasn't a claimant's not entitled to TTD. But the statute says, if you want to talk about the plain language of the statute, it says tolling does not apply to 3 things: impairment, MMI, and compensability. And think about this. If the only thing compensability meant, Judge Bilbrey, was whether or not the claim was covered in the first place, there would never be a tolling event. There's no reason to say that tolling doesn't apply to a compensability issue, because if we haven't picked up the claim as compensable, there has been no provision of benefits, nothing to toll. So tolling can only apply in the way that I'm suggesting it does, or compensability can only be considered in the way that I'm suggesting it does. And you're right, Judge, it's the easiest out of this case. We don't have to go in bonk. We don't have to directly take on this contrary holding in Phillip by simply saying that tolling doesn't apply to this case because the claim was for compensability of the claimant's injuries. That's what's in the petition.
Can I just get one thing from you, going back to the main issue about toll?
Yes, sir.
Going all the way back before Best, do you acknowledge that, had we to do it over again, that the term toll means suspend, and that this use of saying toll means toll or extend was wrong? As an original meaning, just going back to the original use of the term toll as it was commonly understood,
Well,
were the panels
I'm gonna push
wrong?
back slightly, okay? Because the Steele case is the one I cite, but it's Steele versus Commissioner of Social Security. It's 2024 Florida Supreme Court case. And that's the one that said, to arrive at a fair meaning of a term, we consider what a reasonable reader would have understood it to mean at the time of its drafting. And if we consider a reasonable reader, anyone involved in the workers' compensation system, we knew what tolling meant. It meant to extend.
Then why change the statute? I mean, they could have just adopted the way it was before and made tweaks to, make clear that there's not a revival of it or something like that, but they fundamentally
no
changed the
idea.
terminology and used a term that is commonly known in civil practice to mean suspend.
Okay, my only response to that, and I realize I'm in excess of my time, is that, and I quoted it in the brief, why was the 94 law changed? They wrote whereas about 20 times, and every single one of their whereases was that the system is out of control with cost. We must take dramatic action to reduce the costs of the system. And so the argument that we made in Phillip is you take a 2-year statute of limitations, and if you give somebody medical treatment on day 1, you've converted it to a 3-year statute of limitations. And the way that you have described in Ortiz tolling, we get 5, 6, 7-year statutes of limitations because of the way that this math works. And so what they effectively did, if you're correct, is they extended dramatically the statute of limitations, which is exactly the converse of what they were trying to do by reducing the costs of the system and reducing the cost of insurance.
But even in Ortiz, the way that you argued it, it was a 20-year extension. I mean, she was getting benefits for a very long time. The accident happened 20 years prior, roughly. So, I mean,
But
even under your reading with the continuous tolling, you're getting that period of time. It's just, this is a functionality, like just applying the statute as it's written, not this is completely foreign and the statute is always going to be 2 years. It was never written that way. It's never been that way.
Well, Your Honors, the last thing I'll say is we have a clear and express holding in Phillip as to how the statute works, regardless of whether we think that's right or wrong. And I'm asking you to enforce it, or I'm asking you to affirm it. Thank you.
Thank you, Mr. Wagner. And let's add 4 minutes to Mr. Porche's time. You don't need to use it all.
We'll find out. I would like to address first the legislature passively adopting an interpretation. There is no interpretation in Phillip. They do not interpret the word toll. They do not talk about the mechanics, how they arrived at it. And specifically in this case, I raised issue 2, which is, okay, let's assume that toll means extend. And it does in one sense, depending on how you're looking at it. But mechanically, how does it extend? You can't just say extend. Some math has to be involved.
Well, and that's Mr. Rogers' point, is that how then does a claims adjuster or somebody 2 or 3 years down the road discern whether this claim should be payable or not? If there's different clocks and, it's like a speed chess game, the clock is starting and
If you gave me
stopping.
20 minutes, I could program it in a computer, although I'd have to use BASIC. It's quite easy. It's quite easy. And I explained in my brief that, with respect to the clocks, because few people, watch the passing of days by looking at second hands, a calendar works. And it's really easy. It's difficult only if you're clinging to the paradigm that toll might mean a very vague form of extension where the mechanics are unknown, where it's black box. And so they've used the result to force the mechanics rather than studying the mechanics and then figuring out the workaround. And the workaround is very simple. I put it in my brief, and I was not trying to say, oh, this is the Bible, but it's in response to their arguments. It's pretty easy, because if you have payments that are more than 365 days, and that takes no math. I mean, it's either 1 year or not 1 year. If you have payments, all you have to do is subtract. That from that 365, and that's your deduction. But if it sequentially goes uninterrupted, 365 days of payment without it, there's no statute of limitations to think of. And to Judge Tannenbaum's point, the adjuster doesn't have to worry about that. But, I mean, everybody here has I don't know what they call them, an alarm when someone steps on their front porch. I'm pretty sure that if we have a clear understanding. But Phillips did not decide anything, and the legislature can't say we adopt that. because then we get to the second part. Okay, what are the mechanics?
If
From the date of such payment has never been interpreted. So now Phillips is very incomplete, and we wouldn't use, I can't say that. One would not suggest or encourage using an opinion where they said, yeah, there's no definition in the statute, therefore we're going to make one up.
if toll can mean both pause and extend, either one, why is it unfair to look at the 1994 legislative findings that say the costs are out of control, we got to cut this down?
Oh, sure.
Need to keep, we're about to lose the whole comp system. things like
Because at that point in time, you start veering into the falsity of statutory interpretation where you're looking at legislative moods. There cannot be one cost that can be associated with this for good or ill. If you give it to me, so there's many things that were given to the claimant in 1994 that weren't cost measures, meaning not substantive benefits. The 120-day rule, for instance. A statute of limitations that allowed you to treat in accordance with the medical needs rather than clock setting resets. There are some good things out of workers' compensation, and thankfully they did come up with the 120-day, so we're not 20 years down the road arguing for these things.
Well, also, I mean, I had asked at the beginning, if you know of a case where, in Florida, where tolling has been expressly said, as a matter of Florida law, to mean either toll or extend, as opposed to having just toll mean toll, which is what everyone understands to mean, and what the U.S. Supreme Court has understood to mean since the 1980s,
Right.
if not earlier, and what the Florida Supreme Court has understood to mean in the 1990s and the 2000s. So we're talking about a premise that hasn't necessarily been established, right? That toll means toll or extend? That's only according to the first DCA, isn't it?
I think you could casually say it extends to the outside observer because
How?
you're getting, because you're not doing the mechanics. It
Yeah, but
has
you're getting
no-
into now you're getting into the practical or the reality of
Sure.
Sure, as a matter of
The
time,
net
but
effect is that, but it
functionally-
doesn't tell how. How does it give you more time?
Functionally, toll
Functionally,
means-
it
means
can
suspend.
only mean pause or suspend. It can
Right.
only mean that.
So
and I should have been
assuming-
more direct with
so
that. I'm sorry.
assuming, let's just assume that Best and Phillip and all the other cases that have cited it since then are wrong, and that the statute means what it says. The toll means suspend.
Sure.
And let's also assume that the prior panel precedent rule is not really a rule, it's a judicial policy, and it's really just the same thing as stare decisis, and we have to go through all the considerations like set out in Poole. So if we adopt Poole as the perspective, what's your response to, I mean, what I hear Mr. Rogner saying is that, look, maybe it was wrong back then, but there are all these policy reasons why, despite it being wrong, there's ample reason why we should not overrule that concept, such as everyone's come to rely on it. We don't know how to do these calculations now. It's so complicated. I mean, whatever it is. Or our
Yeah.
adjusters will go mad, whatever.
Well,
that
I
is.
think that those are all policy arguments that need to be addressed expressly by the legislature, not
Well, no,
infer-
but if we're deciding
Oh.
whether to, go
Oh,
back
I
to
see.
the original meaning, how do we deal with that?
My first suggestion was we start with the statute, and I don't see the policy. If you cling to the old meaning of toll, I mean, we're here right now. This is an expense under the, if you cling to the old meaning of toll, which has really no meaning, I mean, it simply has no meat.
I mean, is the entire place going to fall apart if we went back to the original meaning of toll? I mean, is the entire work comp system going to collapse?
Not at all. In fact, there could be some instances where they would save money because you don't have to get the clock resetting. So first of all, it's only going to apply to cases where there's a permanent injury, for the most part. It is not going to apply to frivolous case. If you're bringing a case for the first time 3 years after, the law takes care of that. Second, the only thing that happens is the person gets to have the case decided on the merits. And one of the things they have not talked about is the pre-94 law was syntactically different, and there was two different points.
Mr. Porcher, your time's expired,
Oh.
so if you could briefly conclude.
I don't know that I can briefly summarize this. Your Honor, I think it's fair to state that Phillips stands, but it does not decide the issues in this case vis-a-vis the mechanics, especially with respect to issue 2. And toll means toll. Thank you.
Thank you. You may be seated. Our second case on the docket this morning is case number 24-2804, State of Florida, ex rel. Douglas Chertok versus Zillow, Inc. Mr. Jaco, whenever you're ready.
May it please the court, I'm Joe Jaco with the Gunster Law Firm with my colleague George Lemieux. This is the state's enforcement action, the real party at interest, against Zillow for its failure to comply with the Unclaimed Property Act, or the UPA. The trial court made 4 summary judgment rulings. We are seeking each of those rulings to be reversed.
Mr. Jaco, would you like to reserve any time for rebuttal?
5 minutes.
5 minutes, thank you.
Thank you. In those rulings, the trial court committed 2 errors. First, the court resolved disputed material facts. Second, the court misapplied the UPA, in particular to Section 102's general rule for unclaimed property. The UPA's public policy is, quote, to protect interests of owners of unclaimed property. And this court has said the state is the preferred custodian, not a private company. It cannot be that Zillow can keep $6 million that it admittedly does not own. I'll take this court's questions.
You argue that 717-1114 doesn't apply, the 3-year kind of tolling period, for a lack of a better word. Isn't the redemption of Mr. Chertoff and the vast company interest in M&D at issue, an interest defined under both corporate law and LLC law to mean what we're dealing with here, right? So why doesn't that apply?
Thank you for asking, Your Honor. So Section 1101 is an equities exception. Section 102 is the general rule, which we say apply. Looking at subsection 4, the equities exception, there's a number of different amounts, dividends, et cetera, that are listed. However, when you look at the merger-related documents, both in the certificate of incorporation, which is the former shareholder's rights to payment, and when you look at the merger agreement, which is Zillow's duty to pay those former shareholders, it says clearly the amounts are in cash. This is on...
Well, I mean, isn't a dividend cash? You don't normally get a dividend in, like Coca-Cola or something. You get money from the Coke company as your annual dividend, right?
That's right. So the dividend was announced by the former company, NMD, and in the merger, that dividend is now cash.
And the 4 says any dividend. So why doesn't paren 4 apply then?
Well, it's because what is the kind of money that Zillow holds is the question. The kind of money Zillow holds is cash. It used to be dividends when it was with NMD. But after the merger, post-merger, when Zillow has an obligation to pay the former shareholders, it's cash.
Wouldn't it also fall under the definition of a distribution and an interest redemption in 4?
No, Your Honor, and this is at a minimum.
Or other sum, also, or other sum.
Or other sum.
Yeah.
Yeah. This is at minimum a disputed material fact, because when we, again, look at the merger documents, it says what kind of money Zillow holds for the former shareholders. And it explicitly says in the merger agreement, amounts in cash. It says in the certificate, cash. And Zillow even admits that it holds this money in its motion to dismiss. They say they hold this $6 million for the owners, and that, under the merger agreement documents, is in cash.
Would you agree that if paren 4 applies, there's no dispute that there was communication in the 3-year period?
Well, that's right. If it applied, then there's a question, there's a lower threshold of whether those communications expressed an interest. I don't concede that they do express an interest, but under Section 102, which is the proper statute to apply to cash, it's a higher threshold, which is it has to be failed to claim. And this court has said in its Humana case in 1992 that defining what a claim is a demand. And it's absolutely clear when you look at the court's factual findings for the 3 communications that occurred between December 2013 and December 2018. They were 2 emails from Zillow's counsel that went unresponded, and then an email to Zillow notifying them of an appeal. There's no way that those are demands for money. So the 102 threshold is certainly not met, and we wouldn't even say that the 101 is met as an interest.
Now, there was clearly a demand, I think both sides agree, in July 2019. And so why is the state filing a case in 2022 saying that there's unclaimed property when there's a demand was made 3 years prior and both sides agree this money is theirs, but they're bickering over the mechanics of the payments or whatnot? It seems like that takes out the definition of unclaimed. This is claimed money. It's just that there's this bickering going on about interest or about who signs what and what papers need to flow with the money.
Thank you, Your Honor. So once that 5-year dormancy period ran in December 2018, the state takes custody of the money. So that—
It's a May 1st date, I think that you said, as of May 1st, 2019.
That's so.
And you made a demand in July 2019, so maybe there was 2 months in which something different should have been done, but at July 2019, you made a demand, so it seems like even at that point, if they have the money, their obligation is to keep it under the other statute involved in this act.
Well, 2 things, Your Honor. So one, the 5-year dormancy period ran in December 2018. So at that point, the dormancy period closes. Now, we say in our reply brief, that dormancy period used to be, in 1976, 15 years long. In 1986, 7 years long. Then it became 5 years. So the legislature clearly only expected claims to occur in that 5-year period. If they wanted to capture claims outside the 5-year period, they would have left the statute the way it was, 7 years, 15 years. So claims that happen beyond December 2018 do not matter for 102's operation of unclaimed property. Then, as you mentioned, in May 1st, Zillow had an obligation to report that unclaimed property. They didn't do it, right? So they violated the law. In addition, for things that happen beyond that 5-year period that sends the money to the state's custody, there were certainly some type of communication, but what the expectation is that first, a holder would pay the money to the owner. So if that had happened here, great.
Well, weren't they, it seems like the record suggests they've been trying all along.
Your Honor, I mean, one, that's a disputed material fact, right, on whether they have or haven't, but they certainly haven't. I mean, Zillow hasn't paid the money to the owners. They haven't paid it to the state of Florida. They haven't even paid it to New York, where they say it would be due. The point of the UPA is to ensure that a company like Zillow doesn't hold money it admittedly does not own.
You raised the various states involved issue. The 717-1031 talks about the last known address as shown on the records of the holder, which would be on Zillow's records. My understanding is that all times material, Zillow's record showed that Chertok and Vast were New York residents. So I think that's like the third ground for granting summary judgment, but why is that incorrect?
Thank you, Your Honor. So first of all, the court moved to summary judgment when we still had discovery ongoing about this record of Zillow's. We haven't seen it. It's not been verified. So we don't exactly know what the record is. Our discovery was cut short. But in terms of the interpretation of 103, let me say 3 important things. First is that there's a due diligence obligation on Zillow. This is found in 117 subsection 4, and that is on any inactive accounts over $50.
So even though Zillow had a apparently valid New York address for both Vast and Chertok, they nonetheless needed to do due diligence in all 50 states and see where they may be residing, even though they know exactly where they're residing? I mean, that doesn't make any sense to me.
Well, Your Honor, people move. I mean, so this...
But they didn't have any knowledge that they moved. Certainly, if they moved and you've sent, a certified letter and it comes back, undelivered, then you've got some obligation. But apparently all the communications had been received. Right?
Well, Zillow didn't send any kind of certified letter to the owners, trying to verify their address. And, the way the UPA is written is not an obligation on the owners to notify. All of the obligations are on the holder to do
once it
diligence.
becomes unknown. But isn't that the trigger here, that there's got to be, before there's due diligence, there's got to be some unclaimed property and the owner's got to be unlocated, right?
Your Honor, that's not how the statute reads. I mean, section 117.4 says on inactive accounts over $50. That first sentence says nothing about unclaimed property. So that due diligence obligation is just on once a company has an inactive account over $50. And if Zillow decides to do business in all 50 states, then yes, presumably it should be doing this in all 50 states. But that's why the statute lists types of due diligence, such as hiring a company to go out and check public records. If Zillow had done that, as it should have, prior to every May 1st, it would have easily discovered that the owners were in Florida in 2018. I mean, we list multiple records that demonstrate the owners living in Florida. And even Zillow's own website shows that the owners lived in Florida in December of 2018.
When you say we've been saying that when the state took custody of the property, did the state actively do anything, or are you just talking about operation of statute, that it's implicitly goes into the custody of the state?
By operation of statute, that's 103.
All right. And then was there any active communication between Zillow and the state where Zillow in some way was disguising or concealing to the state? I mean, active communications, where they're doing anything affirmatively to hide the ball for the state as the state is trying to take custody of this property?
So we don't know of any communication between Zillow from the time the money was deemed unclaimed and the state would have taken custody of it under Section 103 and this lawsuit. But The fact of the matter is that's why the statutes put the due diligence obligations on the holder, that they are supposed to go and engage in these various methods
Well,
to
but
find out where
there
the owners
seems,
are.
to me at least, to be a difference between a requirement for due diligence and, under the False Claims Act, where it makes it a problem was it knowingly and improperly avoid or decrease an obligation to pay to the state? I mean, there seems to be something more required before you run afoul of the False Claims Act than just not doing due diligence, right?
So Your Honor, two things on that. One, the false claims aspect of this case hasn't been adjudicated yet, right?
Right.
It's not, that wasn't in any part of the trial order. But second, so under the False Claims Act, subsection, this is 68.082, subsections 2 and D, we say that there's a false claim because they knowingly delivered less than they were obligated to. And so at some point in this timeline, from December 2018 or when they were first due in May 2019, through the litigation, there was at some point that Zillow knowingly did not deliver. We will prove that when this case goes back to trial. And so that will be addressed.
And did your client, did you all file a motion under the summary judgment rule saying, the requirement that if you think that there's more discovery to be had and that so you can't properly or fully respond to a summary judgment motion, was that motion filed?
Your Honor, we had 5 motions pending on further discovery, and so.
But did you specifically file a motion under the summary judgment rule?
Your Honor, I'd have to get back to the court on that, and I can file something supplementary on that. But let me at least go back to the question I believe each of you has asked in relation to the state taking the custody under 103. So I mentioned the due diligence obligation. The second piece is the last known address. And there's a clear distinction in the applicable statute, which is 103, and in a statute like 107, which is for life insurers. So this court in the Thrivent case looked at 107 and said that it's the record that establishes the last known address, right? So whatever the record says is what it is. The wording is very different under 103. It says the record must show or must reflect, right? And so the record has an obligation to make evident or to be a faithful image of what we know the last known record is, last known address is. And that last known address is clearly known by the public records. I mean,
Is there only one last known address, or can there be multiple? I mean, it seems like the definition of last known address talks in terms of a place where the person can get mail, and so people could have 10 of those, it would seem.
Your Honor, I think this is part of the due diligence exercise, right? So the definition under 101 subsection 15 is the location of the owner. So that Article V implies that there is one location, and the record needs to describe that. And a way that a holder would be able to describe that is doing their due diligence and identifying all of these public records that show that address is here in Fort Lauderdale. Another important piece under 103 is subsection 3. And there, it talks about the records must reflect the last known address, and if they don't, then it can be established elsewhere. So we know, based on the statute itself, subsection 3 of 103, that the last known address is something independent of whatever record Zillow has. In this case, whatever stale record Zillow has. That independently found last known address is through due diligence.
Does the record reflect that the New York address was a return to sender? Like, nothing would have been delivered there because the owner was no longer there, or Mr. Chertok was no longer there?
If they had mailed it, but, you know, they never mailed it, right? Zillow admitted in their deposition, they didn't do 1 ounce of the required statutory due diligence.
But there was a lot of back and forth. I mean, the whole time it seems like you all are at each other in different forms of litigation. And so you all are receiving each other's mail, it would seem. So my question is the New York address a dead address as far as Vast and Mr. Chertok goes, or is it just not the principal address?
It's not where they are. It's not the location of the owners. So Your Honor, you mentioned other litigation. In 2019, there was a lawsuit that listed the owners in Florida as a Florida liability company. This is something that Zillow clearly has in their records. And one of the due diligence requirements is cross-referencing your own records. So we know as a fact that in 2019, Zillow knew the owners were in Florida. And they just continue, even today, I think.
But at that point, the property had been claimed. You had sent a demand for it. I mean, it seems to me like there's a 2-month window, May to July, where, okay, there's a dispute over whether this property was unclaimed or not. But when you made a demand in July of 2019, that was claimed property. Everybody was on the same page. They identified the sum somewhat, and it was not, it became claimed property. It was unclaimed. It became claimed property that had not yet been delivered, received. The statute uses other words. Delivered over, paid over, dispersed. But it seems like at that point it became claimed property, so that they couldn't have given it to the state.
Well, Your Honor, let me be very clear. So there was no claimed property during the running of the dormancy period. So once that concluded, and once the statute put the property in the state's custody, there's no statutory mechanism to undo that. It's the state's custody of the property in early 2019. So even if there is some subsequent communication, that doesn't undo the fact that the state has custody. That only means that Zillow has even more of a requirement to either pay the owner directly, that's legitimate, or custody. And let me get to that, because that's the court's fourth ruling that goes into section 119.3 and mentions, you know, this idea that you have an erroneous presumption. 2 points about that. One is the court didn't identify anything erroneous about the operation of 102. The money was payable in December 2013 to start the 5-year period. I don't think there's any dispute that Zillow owed the money to the owners in December 2013. It's payable. That's the only time it needs to be payable, is to start that dormancy period. And then there's no claim during those 5 years. Again, I don't think there's any dispute.
No claim. What was the Delaware litigation over?
Well,
I mean, there was a claim. They sued in Delaware, and that were affirmed by the Delaware Supreme Court.
right, one, Your Honor, that litigation happened after the 5-year dormancy period, right? So my point is that in December 2018 to early 2019, it's in the state's custody. Whatever Delaware says about the owners not having a contract remedy anymore because the statute of limitations has expired, that does nothing to halt the state's enforcement action in the state's custody.
And you're correct. Let me apologize to you, but I've mixed up the Delaware and the New York. There was a New York litigation going on in 2017 during that 5-year period, right, over a settlement agreement.
So, in Honor, that's probably the very reason why there wasn't a claim, because that litigation had nothing to do with this amount of money, this $6 million. That litigation had to do with intellectual property rights. It had to do with, you know, the fact that the company was, you know, from the owner's perspective, sold out from under them. It had to do with other issues related to the merger, not the amount of money. So during that 5-year period, the owners didn't want to pursue the $6 million because they were litigating over the company itself, which was what they would rather have, and their intellectual property rights, which they wanted from the company. They didn't want to acquiesce that federal litigation in some way by claiming this property. So that's why you don't have a claim during that time period, during that entire federal litigation. But in terms of the other Delaware litigation, all of that's subsequent to the running of the dormancy period.
Your time has expired, but why don't we do this? Why don't I give you a couple minutes for rebuttal, and let's add 5 minutes to the appellee's time, and we'll go from there.
Thank you, Your Honor.
Thank you. Mr. Jackson.
Thank you, Your Honor. May it please the court. I'm Ty Jackson, along with my co-counsel Jason Unger. We have the privilege of representing Zillow in this matter. Your Honors, this court should affirm the court's judgment in favor of Zillow and denying the relator's summary judgment for 4 primary reasons. First and foremost, as is apparent, Mr. Chertok is not missing. He's never been missing. He's certainly not missing today. There is no unclaimed property. The Unclaimed Property Act has no business in this case. The relator has brought this case as the relator. It's not brought by the state. It is brought on behalf of the state. The state looked at this, said, we're not going to intervene in this. Mr. Chertok deposed the Department of Financial Services Division of Unclaimed Property representative in this case, who had been with the division for 23 years, who said, knows about it, he's aware of it, don't send it to us. We would just have to process it to send it to him. It's not unclaimed. We don't want anything to do with it.
So your point is it's been claimed property all along. It just hasn't been delivered yet.
Well,
Or
Your Honor,
something along that line.
I would contend and will contend there is no property here that's due.
Well, your
or
motion to
payable.
dismiss admitted that we're trying to send them money, but we haven't worked out the details essentially yet.
Yes, Your Honor, under the merger agreement. The merger agreement and the NMD certificate are 2 separate standalone bases for this potential property to be owed. Zillow has maintained since 2013 that if the relators and Vast Ventures, who he owns and controls, had satisfied the conditions precedent under the merger agreement, which the evidence in the record in this case shows he has never done, he would have been entitled to property under the merger agreement. He's never done that. And in this case, he said in the complaint, we're seeking the property under the NMD certificate, not the merger agreement. He underlined, bold, and italicized the word not in his complaint. I asked him about that in his deposition. He very clearly testified, I'm not seeking this under the merger agreement because he knows, 1, he doesn't get interest under the merger agreement, and 2, he's never satisfied the conditions. Under the NMD certificate, there is no property. That's essentially a breach of contract claim. He says, you breached the contract, and we said, no, we did not. If you look at the certificate, if you look at the complaint, he clearly says the certificate. You look at the certificate, it talks about distributions, dividends. Zillow has maintained from the beginning they don't owe him anything under the NMD certificate, never have. He sat on those rights until December of 2019 when he sued in Delaware. Delaware Supreme Court said, you missed the boat back in December 2016. There is no property that's due or payable to Mr. Chertok or Vast Ventures under the NMD certificate, never has been, never will be. He has no right to establish it. Florida has a statute, 95.10, says if the statute of limitations has run in the state where the claim arose, you can't bring it here. He can't bring that. He's attempting to revive his stale rights by bringing this case. So there is no property. As the trial court correctly found, even if there was property, it's not presumed unclaimed. I would respectfully submit to you the trial court correctly applied the 3-year dormancy period in 717-1101 sub 4.
Well, one of their arguments is, well, that doesn't apply because this is, the dividends got converted to cash. What's the response to that?
Well, Your Honor, your point exactly. Dividends are given to you in cash, but the point of 11014 is that these are sums that arise out of equity interests in a business. It talks about dividends, distributions, other sums payable to a shareholder as a result of their equity interest in the business. That's exactly what this is. There were dividends, and if you look at the complaint, they say that the merger consideration, as they define it, arises out of the NMD certificate, Article 4th, Section C, paragraphs 2.2 and 2.3. The title of 2.2 is distribution of remaining assets, and it talks about distribution if there's an event such as a merger. These are clearly dividends and distributions to shareholders arising from their equity interests. The 3-year dormancy period in 11014 is exactly what applies. Even 102 explicitly acknowledges at the end of the sentence of the section that they cite to, the 5-year, except as otherwise provided. It acknowledges there are specific types of intangible property that are subject to specific periods. I would also point out, Your Honor, there's a rule that defines presumed unclaimed. And that rule states, says presumed unclaimed means, quote, the apparent owner has not indicated an interest in the property for the applicable prescribed period. That rule implements 717-102 and 1101. So I would argue that even if the 5-year applied, it's still, if the owner is apparently aware of the property, it's not unclaimed. But going back to the 3-year, there was ongoing litigation between December 2013, if that's when the dormancy period started. We contend it did not start ever. But if it started in December 2013 and went through December 2016, there was ongoing federal court litigation over the issues from the merger. Mr. Chertok and Vash were trying to overturn the merger so they could get this alleged money through a different route, get the interest on it, get their ownership interest back in the company. It related to the issues in this case. They obviously were aware of one another. They were steadily communicating with one another throughout that litigation that didn't end until May of 2018. They also had emails during that time period that are in the record where they were communicating. There was a sanctions issue. Zillow's counsel emailed Mr. Chertok's counsel and said, hey, realize you got sanctioned. We got this issue. Can we get this worked out? His counsel wrote back and said, I don't represent Mr. Chertok anymore, but I've sent your email on. A couple days later, Mr. Chertok responds to Zillow's counsel and says, I've filed the notice of appeal, and we're moving forward. So it wasn't unclaimed, but even if it was unclaimed, as of December 2016, it's undisputed in the record that Mr. Chertok and Vast Ventures were actually still in New York. Set aside the address of record issue. They had no connection to Florida in December 2016 whatsoever. So if you agree it's the 3-year dormancy period, even if you find that the court was wrong, that it was never presumed unclaimed, it would have gone to New York. There was no obligation to send it to Florida. Their next argument is, as you know, well, it should be the 5-year dormancy period. Again, the rule defines presumed unclaimed that applies to all of the Unclaimed Property Act. I don't agree there's a difference. It was not unclaimed as of December 2018 for the same reason it wasn't unclaimed as of December 2016. Even if it was presumed unclaimed, it still doesn't go to Florida for a couple reasons. One, Vast Ventures LLC, a Florida limited liability company, in the record, did not obtain any interest, even potentially flowing from the NMD certificate or the merger agreement, until May 6th of 2019, which is after the property allegedly should have been sent into the custody of the state on May 1 of 2019. So it couldn't have been subject to a sheet to Florida in 2019. But aside from that, the address of record, as shown on Zillow's records, to this day, is New York. And to this day, it's New York because even throughout this litigation, when we said, do you want us to change your address to Florida? Refused to do it over and over again, refused to answer those questions in the deposition, refused to say, yes, change my address to Florida, has never sent a request to Zillow to change his address to any address other than the one in New York that they've had since 2013 when NMD merged into Zillow and Zillow received NMD's records that showed the address of record for the shareholders in NMD. That's how they got it. As to the evidence, Ms. Cartalis, which is Zillow's rep, in sworn interrogatories, said the address of record as shown on Zillow's records is in New York. In her testimony and deposition, by questioning by Mr. Chertock's counsel, she said address of record is in New York. In a declaration, she said that. Repeatedly, she said the address is record. They said, where did that come from? So we provided the actual document where NMD Interactive provided the addresses to Zillow as a part of the merger. It's part of Zillow's business records. Ms. Cartalis testified to that. It's not unauthenticated. It's been authenticated. It's not hearsay. It's a business record. That's shown up in the record. But I would submit to you that's irrelevant. We have specific testimony from Zillow that that's the address on their records. You don't need anything further. And there is not even a scintilla of evidence, not that that would be sufficient, that the address was something else on Zillow's records. If you look at the admitted complaint, it's devoid even of any allegation that Zillow had a record that showed a New York address for Chertock or Bass. It's not even in the complaint. The complaint's completely deficient on that reason anyway.
Is there, can I just ask, functionally, is there a difference between being in the custody of the state and the state actually owning it or being property of the state?
Yes, Your Honor, there is. That issue did not come up in this case specifically because we have so many reasons, but there's currently a case pending in the federal district, in the Northern District of Florida, where a class action, they're trying to get it certified as a class, is suing the state of Florida, claiming that the interest that the state tries to keep when it has money in its custody is an unconstitutional taking because unlike a true escheat statute, the Unclaimed Property Act is a custodial statute except for very specific types of property which are not at issue in this case. The state, to your point, takes custody, and the statute says as soon as they identify the owner comes forward, they must give them over the money. They're just taking custody of it. Right now, they take custody of it, they put it in the school trust fund, they earn interest on it, they keep that money, they give back the principal. This suit, it was filed in the Northern District, it went up on appeal because it was dismissed. The 11th Circuit said, no, I think there's something here, so it's back down in front of Judge Hinkle, I think it is, currently, before the court, alleging a Fifth Amendment taking because it's
Sure.
not.
So then make the distinction between what is the relationship of a custodian to a possible owner of that property and an actual owner of the property. I mean, there is a difference between those two relationships, right?
Yes, Your Honor, there is. And we did
Like a
address.
custodian doesn't have a property interest in the property that has custody of. It's holding it almost in trust for someone else.
That's correct, Your Honor. Under the Unclaimed Property Act, the state is holding it as trust for the owner, which is why when we deposed the division's representative, they said, don't send it to us. He obviously knows about it. We'd have to hand it over to him. And interestingly, and this is in the record, Mr. Chertock currently is suing an entity for allegedly improperly turning over property to the state of Florida as unclaimed property when he was in communication with them about a merger out of which this money arose. The case is still pending in the south part of the state. It was in state court, federal court, went back to state court. I think it's now back in federal court. But he's actually taking the exact opposite position in that case. He contended in his deposition when I asked him about it, well, I'm not here as Chertock, I'm here as the state. That's Douglas Chertock individually, so those things are not inconsistent. They are.
So, this case comes as we have judgment in your client's favor, right? So it knocks out the complaint, it's res judicata. And what that is essentially saying is that they don't have a False Claims Act suit against your client.
That's correct.
Agree with that? So we could affirm on any basis appearing in the record, including is there actually even any cognizable claim under the False Claims Act, right?
Correct, Your Honor. And
So I asked you the same question I asked Mr. Jacob about looking at the False Claims Act. So if the state at best would have custody and not actual ownership of it, is a fair reading of 68.082, in particular, say 2G, is a fair reading of that include, well, the state actually has to have some sort of ownership interest in the property for it to be a false claim?
I would posit to Your Honor that it does. And the legislature actually, after this came about, the legislature actually considered putting something in the statute to make that clear. It was in a bigger bill and didn't go through. Sure. But the Division of Unclaimed Property very clearly thinks that this is not an appropriate False Claims Act situation.
I mean, has there been another example where the False Claims Act has been used in this manner to enforce an unclaimed property?
Your Honor, I'm not aware of one. I'm not aware that one has come before. I mean, honestly, again, just looking at it from a distance and saying, okay, the alleged apparent owner is here saying that there's unclaimed property that should be escheated to the state. He is the alleged apparent owner. He is here. He obviously has knowledge of this purported property. The Unclaimed Property Act has no place here. And I think the trial judge in the final summary judgment said, look, clearly, at least when he filed this lawsuit, he had knowledge of the property and it wasn't unclaimed. And under 1193, it clearly says if for any reason it appears that it's erroneous, the presumption that it's unclaimed, you don't turn it over to the state. Mr. Chertock's response to that is, well, yeah, but you're supposed to send a statement to the state telling them that you think that it was erroneous. Well, Zillow never thought that it was unclaimed or that there was any right to property under the NMD certificate or the merger agreement, so they didn't send anything. But to your point, Your Honor, even if they were supposed to provide a statement, that's not property. It can't support a False Claims Act case. And we did, in the pleadings in this case, we did talk about the fact that it has to be knowing and improper failure to pay it over. They've certainly not showed that they've not shown that Zillow thought they had an obligation to pay any money or thought that it was presumed unclaimed. They certainly haven't shown that it was knowing and improper. And to Your Honor's question about discovery, we filed an earlier motion for summary judgment. And Mr. Chertock argued, we can't go to summary judgment yet, we need to do more discovery. After that, they did numerous depositions, additional discovery. This was one of the most heavily litigated discovery cases I've ever been involved in. I mean, just numerous motions to compel, to sanction me for allegedly not complying with discovery, none of which were upheld or granted. But there was extensive discovery after the filing of the first motion for summary judgment. There were motions that were filed at the very end, at the close of discovery, saying we need even more time, but those were filed a couple days before the discovery period was to end. There was plenty of chance to do discovery. There's no facts to support their case. Your Honor, I see I have time left. If there are other questions, I'm happy to take those.
Mentioned all the litigation going on. One of your issues, you filed a motion for appellate attorney's fees. If we agree with you and affirm the summary judgment, is that something that we can decide? You know, I hadn't seen a lot of qui tam actions. Is that something that we decide? Is that something we kick down to the trial court? Or her findings on the consistently and repeatedly pursued Zillow sufficient? What would, if you win, what would you have us do on that?
Your Honor, if we prevail, and again, I think we prevail for a lot of reasons, but the one to me that is just the most obvious is that Mr. Chertock is here. He's obviously not missing. He's not been missing ever. He certainly hasn't been missing since he filed this lawsuit. The trial court entered a finding that he knew all along that he was not missing and that this case had no merit. We have a motion for fees pending in the trial court. She stayed that pending the outcome of this. We filed a separate motion for appellate fees. I think, Your Honor, you all would be looking at the motion, assuming you rule in our favor, you would look at the motion to determine whether or not it meets the standard for fees on appeal, either grant or deny that. If you grant it, my understanding is that would go back down to the trial court to determine the amount of fees, which I assume at that time she would also take up our motion for trial fees on the same grounds and take a look at that.
Thank you.
Your Honor, if you have no further questions, for the reasons we've talked about today and for the additional reasons that are set forth in the answer brief filed in this matter, we would respectfully ask that you affirm the trial court summary judgment in favor of Zillow. Again, if you find any one of the reasons that the court found, many reasons, you're required to affirm, and that you should deny the summary judgment or affirm the denial of the summary judgment for Chertock, the relator, on the same grounds. Thank you very much.
Thank you, Mr. Jackson.
Your Honors, Zillow is a big company. If it is allowed to bury its head in the sand and keep $6 million it admittedly doesn't own, it's going to incentivize other companies to do the same thing, to earn interest on that money, to avoid legal obligations, when the entire purpose of the UPA is to remove the money from Zillow and either give it to the owners or for the state to hold it until the owners come forth or the state identifies that it should go to the owners. But the one thing we know, whether the money goes to the owners or to Florida or New York, it should not stay with Zillow, and that's what the trial court's opinion does. Your Honors, let me address a few things. First, Judge Tannenbaum, you asked about the False Claims Act. 67.0822G allows for a false claim when Zillow knowingly avoids an obligation to transmit, quote. So that is what they're doing by holding this money and not giving it to the state when the state has custody.
Yeah, but what's the state going to do when it's transmitted?
Your Honor, the very point of the UPA is to get it out of the hands of Zillow. Once the state has it, if there's an owner, presumably they'd give it to the owner. In this case, Zillow's unwilling to give it to the owner. So it's just holding the money. It's been holding the money for 12 years. And so the operation of the UPA is to allow the state in this instance to appropriately give it to the owner. But that's the violation of the False Claims Act, is right there in subsection 2G.
But under your theory, either Zillow is like the custodian of this property or the state is custodian of this property, holding it for the benefit of your client. And it's kind of like a fiction to say it's actually needed to be transmitted, and their failure to transmit it to the state is a false claim. And I'm having a hard time following that. If the state doesn't have ownership in it, doesn't have an ownership interest in it, and your client's claiming ownership interest in it, and it really doesn't matter who actually has it, I'm still not following where
Well, this
the
court
claim
said-
actually arises.
This court has said clearly in Petrona's case that the state is the preferred custodian. So that's clear. It should be with the state, not with Zillow. Whether at that point there's a violation of the False Claims Act, we would say that it's right there in the failure to transmit, but we would submit that to the jury and let the jury decide. If I can quickly, let me address 5 things that my friend.
Your
No,
time
I'm
has
just going
expired, Mr.
to
Jacob,
rapid
but
fire.
you may briefly conclude.
Okay, but then I want to address the 5 things, but they're all in our papers. But Your Honor, this idea at the very end of the owners being missing, the UPA operates either way. If they're missing and the state can find the owners, fantastic. Then the money can. If the company is unwilling to give the money to the owners, then it goes to the state to go to the owners. If, as the Department of Financial Services testified, the money can be given directly to the owners, then they don't need to be a part of it. And that's all the department was saying, is we don't need to be a part of this if Zillow gives the money to the owners, but Zillow can't keep it. Thank you.
Thank you. All right, that concludes our last argument for the day. We are adjourned.